6 weeks after my husband walked out, my mother-in-law showed up at my front door in Mississauga with a folder full of papers and a smile I had not seen on her face in years. She did not knock. She had a key, one I had forgotten she still had, and she let herself in while I was upstairs putting my daughter to bed. I heard the door open, I heard her heels on the hardwood, I heard her call up the stairs, "Zoe, come down, we need to talk about the house." My daughter was 3 years old. Her name was Maya. She had just fallen asleep with her stuffed rabbit tucked under her chin, and I stood there in the dark of her room for a moment, looking at her, breathing slowly. 6 weeks. I had been holding things together for 6 weeks on almost nothing, working remotely during nap times and evenings, making oatmeal and cutting grapes into quarters and telling myself one more day, one more day. I came downstairs. My mother-in-law was sitting at my kitchen table. She had taken off her coat and hung it on the back of my chair. My chair, the one I always sat in, and she was pouring herself a glass of water from the pitcher I kept on the counter. Her older son, my husband's brother, was standing near the sliding door with his arms crossed. I had not known he was coming. "Sit down," she said, not unkindly, in the way someone says it when they have already decided how the conversation will go. I sat. She opened the folder. There were mortgage documents, a printed bank statement I did not recognize, a letter on legal stationery that I did not have time to read before she began talking. "You know your husband co-signed on the HELOC," she said. "2 years ago, $83,000. That money went into your renovation, the kitchen, the deck out back." She paused. "The debt belongs to both of you." "He left," I said. "Yes," she said, "and the debt stays with the property." "Which means it stays with you, unless you want to sell." Her son unfolded his arms long enough to tap the table once, as if affirming something. He did not speak. He rarely spoke in these moments. He was there to take up space. I looked at the letter on the stationery. A law firm, downtown Toronto. The kind of firm with 3 surnames in the title. "He retained a lawyer?" I said. "We retained a lawyer," my mother-in-law said. She used that word carefully. "We." As if this family had ever included me in a "we." She told me the plan simply, the way people tell you things when they do not expect resistance. My husband would not be returning. He had moved on. She used that phrase, "moved on," as though leaving a 3-year-old daughter was a lifestyle choice rather than abandonment. The property in Mississauga had appreciated significantly. According to their lawyer, the cleanest resolution was a forced sale. Split the equity after the HELOC was repaid. Her son was prepared to purchase my share, she said, which would mean I could rent somewhere smaller and have a little money left over. A little money left over. I had worked full-time since I was 19. I had a master's degree from McMaster. I had been contributing to the mortgage on this house since the day we signed. But I had taken 8 months of parental leave, and during those 8 months my husband had handled the finances, and somewhere in that fog of nursing and sleeplessness I had signed things I had not read carefully enough. I knew that. I had already spent 6 weeks losing sleep over exactly that. What my mother-in-law did not know was what I did for work. She had never asked. In 4 years of holiday dinners and birthday gatherings, she had asked me exactly twice about my job, and both times she had moved on before I finished answering. I was her daughter-in-law. I was the mother of her grandchild, who she had seen 11 times in 3 years. I was background. I looked at the letter again. I looked at the bank statement. "Can I keep this?" I said, touching the folder. She hesitated. Then she slid it across the table. "We have copies." "Of course," I said. I stood up and I walked to the kitchen counter and I filled a glass of water for myself, and I stood there with my back to both of them for a moment, looking out the window over the sink at the backyard. The deck they were counting as debt. I had sanded that deck myself, 7 months pregnant while my husband was at a work event in Vancouver. I had stained it in sections over 3 weekends. I knew every board. "I'll need some time to review these," I said. "Of course," she said. "But the lawyer would like a response by the end of the month." Her son made a small sound, agreement or impatience. Hard to tell. They left 20 minutes later. I stood at the front window and watched their car back out of the driveway, and then I went upstairs and checked on Maya, and then I sat down at the desk in the small room I used as a home office and I opened my laptop. Not to cry. Not to call my mother. Not to Google what to do when your mother-in-law threatens to sell your house. I opened my laptop because I had work to do. I am a compliance analyst. That is the title on my LinkedIn, the one my mother-in-law would not have looked at because she did not think about me in those terms. What that means practically is that I spend my days reviewing financial transactions for patterns that do not fit. I work for a firm contracted by several Canadian financial institutions. I am trained to find things in numbers that people think they have hidden. I hold a designation from a CAMS. I have given evidence in regulatory proceedings. I once flagged a network of accounts that unraveled into a 7-figure insurance fraud case. I am very good at finding things. I started with the HELOC because that was the foundation of everything they were building on. A home equity line of credit for $83,000, co-signed by my husband. I had signed too, I knew that, but I had been told it was routine, that we would pay it off within 2 years, that it was a better rate than a personal loan. What I found in the first hour was that the draws on that HELOC did not match the renovation invoices, not even close. The kitchen renovation had cost $41,000, the deck had cost $9,000, that was $50,000 accounted for. The remaining $33,000 had been drawn in 4 separate transactions over 14 months, all in amounts just under the automatic reporting threshold, all transferred to an account I did not recognize. I recognized the pattern immediately. I work with this pattern for a living, I kept going. By midnight I had pulled every document I could access. Our shared accounts, the property records through the Ontario Land Registry, my own credit file, which he had also accessed, I discovered 3 times in the past year without my knowledge. There is a legal mechanism for a spouse to access joint financial information. There is not a legal mechanism for what I found next. He had applied for a second mortgage, not a refinance. A second mortgage registered against our property for $120,000. The application was dated 4 months before he left. It had been declined. I found the refusal notice in a folder he had apparently forgotten was synced to our shared cloud storage. But the inquiry was there, hard and clear on the property title. He had been trying to leverage our home without telling me. And when that failed, he left. I sat back. I thought about my mother-in-law's face at my kitchen table, the smoothness of it, the rehearsed calm she had known. I did not know how much she had known, but she had known something, and she had shown up with a lawyer's letter and her son as a witness, and a plan that depended entirely on me being exactly who she thought I was, a woman alone, overwhelmed, probably behind on things, probably desperate enough to take whatever they offered just to make it stop. The next morning I called a family law lawyer. Not any lawyer, a specific woman I had met at a professional development event 2 years earlier, who had handed me her card after we talked for 40 minutes about the ways financial abuse goes undetected in marriages. Her name was Fernanda, and when I called her office at 8:45, she picked up herself. I told her what I had. She was quiet for a moment, then she said, "Send me everything. I'll clear Thursday afternoon." I spent the next 3 weeks doing what I do. Methodical, documented. I built a timeline of every financial transaction I could trace, beginning 4 years back. I requested our full credit history. I filed a formal complaint with the Financial Consumer Agency of Canada regarding the unauthorized credit inquiries on my file. I contacted the lender for the HELOC and requested a full accounting of every draw and transfer. I corresponded with the Ontario Land Registry about the second mortgage application, which I had flagged as a potential title issue. I did not tell my mother-in-law any of this. She called twice during those weeks. I answered both times calmly, and I said I was still reviewing the documents and I appreciated her patience. She asked once whether I had spoken to a lawyer and I said I was looking into it. She made a small sound, the same sound her son had made in my kitchen, and moved on. Meanwhile, I found the account. The $33,000 that had left the HELOC had gone to a personal account in my husband's name alone, opened 6 months before he left. From that account, money had moved to a joint account I had no knowledge of. The second account holder was not a business, it was a person. I found her name through a sequence of steps I am not going to detail, because the process matters less than the outcome. What matters is that I found her, and I found that they had been together for at least 2 years. And I found that a significant portion of the equity he had been trying to extract from our home had been going toward a down payment on a condo in Hamilton that was registered in her name with him listed as a beneficial owner. He had been building a second life with my money. In the 4th week, Fernanda sent the formal response to their lawyer. I was not in the meeting, I did not need to be. Fernanda told me afterward that she had opened by placing our documentation on the table. the HELOC discrepancy analysis, the title search results, the FCAC complaint confirmation, the second mortgage application, and the annotated account transfer records, and that she had allowed their lawyer approximately 4 minutes to read before she began speaking. Their lawyer, Fernanda said, had stopped her once to clarify something about the HELOC transfers. Then he had not said much at all. By the end of that meeting, the demand for a forced sale had been withdrawn, but I was not finished. Because the issue was never really the house. The house was just what they had pointed at, assuming it was all I could see. I submitted the full financial documentation package to the relevant authorities. A HELOC drawn down through structuring transactions. Transactions designed to avoid triggering reporting requirements. Is not a civil matter. It is a regulatory one, and a beneficial ownership arrangement on a property acquired through funds traced to marital assets while a divorce was being structured? That is a matter for a forensic accountant and a family court judge with very little patience for this kind of maneuvering. I filed for divorce on the basis of adultery and financial misconduct. Fernanda filed a motion to have the Hamilton condo considered a marital asset. She filed a separate motion relating to the undisclosed HELOC transfers. She contacted the lender directly, providing our documentation which triggered their own internal review. The end of the month came and went. My mother-in-law did not call again. I heard from my husband's brother, not through his mother, not through the lawyer, but through a mutual friend who seemed to think she was being helpful, that they were reconsidering their approach. That was the phrase. Reconsidering their approach, as though they had simply suggested the wrong color for the living room walls, and were now thinking about beige instead. The family court hearing took 5 months. I attended every session. At one of the early appearances, my husband's lawyer made an argument about my financial culpability in the HELOC, suggesting I had been an equal and informed participant in all decisions. It was the kind of argument that works when the other person cannot demonstrate otherwise. I could demonstrate otherwise. I had the cloud storage logs. I had the communication records. I had a time-stamped analysis showing that the 4 HELOC transfers had been initiated from a device that was not mine, at times when I could document being elsewhere, twice while I was at the hospital for Maya's 18-month vaccinations. The judge looked at my documentation for a long time. She did not use the word fraud in her ruling. Judges rarely do in this specific context. But she found that the HELOC transfers had been made without my informed consent. That the funds had been used for purposes unrelated to our property. And that the Hamilton condo represented an asset acquired through funds that were subject to equitable division. She ordered a full accounting by a court-appointed forensic accountant. My husband's lawyer asked for an adjournment. The judge said no. The final settlement took another 3 months to negotiate after the forensic accounting was complete. I will not give exact numbers because that is not the point, and also because some of it is still subject to confidentiality terms that Fernanda recommended I respect. What I will say is this: I kept the house. Maya kept her room, her backyard, the deck I built with my own hands. The HELOC was allocated to my husband's share of the settlement as undisclosed marital debt. The Hamilton condo was included in the asset pool. The forensic accountant's findings were referred to the relevant regulatory body. That process is ongoing and not mine to speak about publicly. The last time I heard from my mother-in-law was a voicemail she left 2 days after the final settlement was signed. She said she hoped I knew what I had done to this family. She said she hoped I was satisfied. I listened to it once. Then I saved it to a folder on my desktop, clearly labeled with a date stamp. Old habit. Maya is 4 now. She is in junior kindergarten at the school 3 blocks away. And on Wednesday mornings I drop her off and then walk to the coffee shop on the corner and sit by the window for 30 minutes before I start work. And I think about how differently this could have gone. If I had been someone else. If I had taken that folder and panicked and signed something in a hurry just to make the feeling stop. I think about the woman my mother-in-law thought she was sitting across from, exhausted, alone, probably behind on the mortgage payments she did not know had been restructured without her consent, probably grateful for any offer that looked like a solution. She was not wrong about the exhausted part, she was wrong about everything else.